It's a pleasure to be all of you. Today, I'm actually in Washington, D.C., attending a conference related to my practice, and I had the pleasure of walking past the Capitol a few moments ago. Cherry blossoms are still blooming. It's a little overcast here, but certainly feels like spring, and delighted to send my greetings from Washington to all of you. And we have a full program today. As you might expect, there's a lot happening, and I will walk you through the agenda. You'll hear from me momentarily about the New York State budget. After that, we'll have Caroline Westover, who's with us from our Syracuse office and who focuses, among other areas, on immigration law. There is a lot happening in that space in the context of the new federal administration, and there's some specific attention to social media policy that Caroline will update all of us on. Kyle Ritchie is with us from our Kansas location, and we're grateful to have him back on the program. He has spoken about healthcare, or excuse me, higher ed and athletics, forgive me, a number of times over. And there is, speaking of spaces where there's a lot moving and changing, plenty to say there, and Kyle will provide us with the update. And then Katie Stifler will be with us from Rochester. Katie is new to the program. I've had the pleasure of working with Katie already since she joined Bond last year, and she's a real attribute to the firm, and I think you'll all enjoy getting to know her. She works in education law primarily, and she will be sharing information concerning the free appropriate public education plan, which is relevant certainly for those of you in the school law world, and we think it'll be useful for some of you more broadly to have some takeaways. But before getting into those presentation elements, let me walk you through what's happening in New York State with the budget. And what I will tell you is that primarily we are in a place where we haven't gotten to decision points. I had warned you last week when I was hosting that if we didn't get a quick decision on the budget, we might be waiting until May. It looks like that's what's likely going to happen. The governor has been publicly voicing the fact that May is likely, and that further, she does not, in her view, see constituents pushing back and raising concerns about that. And she's interested in negotiating for those issues that are important in her view, among them those discovery laws that we spoke about, the involuntary commitment standards, et cetera. There's a lot happening in those elements that are left out of the budget. The consumer-directed personal assistance program, the rollover to the new program has been delayed. There have been federal court activities. The Department of Health and Human Services is actually looking into the transition. So much more to come, but the budget is still silent on it. And we'll also note that with MTA financing, as we know, the litigation is ongoing as between the federal government and New York State about whether the program continues. That'll have an effect on New York State's budget indubitably, but we don't know the outcome to that yet. And it'll probably be later in the summer, that, if not the fall, that we get a fuller sense of what that means. In the interim, since I was with you last week, there's been a major announcement for those of us in the healthcare policy world concerning the Federal Department of Health and Human Services, specifically Centers for Medicare and Medicaid Services approach to the 1115 waiver amendments across the country. There will no longer be support for essentially social care, which in connection with waivers, according to the administration, which has a direct effect on New York State's waiver. The waiver funds are, from everything we know, set through March of 2027. But the policy shift suggests strongly that after March of 27, there will not be a renewal. So we'll be tracking that all very closely. As I've mentioned before, there are literally billions of dollars that New York State and partners within the state are working on spending in the context of that award going back to 2024. And this will have, I think, significant emanations for all of you over the course of the remainder of spring into summer. So we'll be reporting back on that. It's not per se directly relating to the budget, but certainly money in New York State. So I wanted to raise it to all of you. As soon as we know more about the budget proper, we will make sure all of you get those updates. And in the interim, though, with that background, excuse me, provided, I want to next turn it over to my colleague in Syracuse, Caroline, who is with us to provide a quick update, as I mentioned, on immigration law relating specifically to social media. Caroline, the floor is yours, and thank you for coming back. We always appreciate hearing from you.
Gabe, good to be with you and good to speak with all of you this afternoon. The topic today is really a very brief, discrete item, but has a broad application regardless of your industry or your visa status or classification. So this update is coming to us from an announcement that the U.S. Citizenship and Immigration Service Agency made last Wednesday on April 9th. Specifically, the agency on April 9th announced that they would begin considering a foreign national's social media activity as a basis to deny immigration benefit requests. So specifically, the announcement said that they would be looking at items such as anti-Semitic social media, as well as comments about physical harassment of Jewish individuals. There is no grace period for this guidance to come into effect. They said it was effective immediately. So as of April 9th, this is now the standard moving forward. So certainly this is a timely update for anybody that this may pertain to. But according to the USCIS announcement, this guidance is going to be applicable to foreign nationals seeking benefits in a couple categories. The first would be permanent lawful residency. The second is for foreign students, and the third is for foreign nationals affiliated with educational institutions linked to anti-Semitic activity. Those are the three categories that they've identified in terms of the application. And while this announcement from USCIS does not expressly mention other categories or highlight foreign nationals, for example, in non-immigrant categories, H-1B workers, L workers, O's, TNs, and the like, I think it's a fair assumption here or assessment to assume that this standard will also be applied to those individuals who may be seeking a benefit to come here, even if it means temporary work in the U.S. So social media content certainly on the forefront and is now fair game for anybody making a request to immigration services or potentially the Department of State to be able to come into the U.S. in some immigrant category. I think it's helpful to understand what serves as the basis for this new guidance. Where is it coming from? What is prompting it? In short order, the answer is 3 executive orders thus far. The first, entitled Combating Anti-Semitism, has already been around. It was issued in 2019 during the first Trump administration. The second executive order, entitled Additional Measures to Combat Anti-Semitism, was issued by the current administration earlier this year in January 2025. And then the third executive order is entitled Other National Security and Public Safety Threats, also issued here in 2025. So in order to enforce this new guidance and the policies and intentions set forth in these executive orders, the Department of Homeland Security, as we all know, which has been very, very active publicly and behind the scenes in this current administration, announced that they will enforce relevant immigration laws to the quote unquote maximum degree to protect the homeland from extremists and terrorist aliens. This April 9th announcement coming from USCIS, when they identify extremists and terrorist aliens, their terminology, has also said that this can include individuals who support anti-Semitic terrorism, individuals who support anti-Semitic ideologies, and anti-Semitic terrorist organizations. The administration listed several of those anti-terrorist, anti-Semitic terror organizations, including but not limited to the following: Hamas and Hezbollah. Both of those were designated as terrorist organizations back in 1997. Palestinian Islamic Jihad, who was identified and designated as a terrorist organization in 2014. And more recently, Ansar Allah, also known as the Houthis, designated last month in March 2025. So certainly any connection to those individuals or any ideologies or expressions on social media sympathetic to those organizations, I think it will certainly fall under the enforcement mechanisms of what this current administration is trying to do. In short order, the social media content that the USCIS, quote unquote, may consider or look for would be anything to indicate a potential foreign national is either endorsing, espousing, promoting, or supporting these anti-Semitic terrorism activities, terroristic organizations, or anti-Semitic ideologies. If this type of social media content is found on a foreign national's devices or is publicly available through other sources, the USCIS has clearly indicated that it will view this content as a negative factor when evaluating a foreign national's application for immigrant benefit requests and when adjudicating these applications, anywhere where the USCIS has discretion. And having practiced in this area for 2 decades, I think any practitioner could tell you that there is a fair amount where the USCIS has discretion. And so everybody's on notice that this is now going to be counted as a negative factor if it is found in connection with a person who's making a request for benefits. And I think as we close this piece out, Gabe, I just want to mention that this is really not the first time that the USCIS has made a reference to monitoring or screening foreign national social media content in connection with applications or requests for immigration benefits. In 2015, the Obama administration created a pilot program for this very purpose. And the following year, in 2016, the Obama administration created a social media division within the fraud unit of the USCIS in order to identify and detect potential risks and potential fraud for individuals who are coming within our borders. So what this April 9th announcement really does and what it means when it's been published by the USCIS is really just a simple reminder to all of us that social media content and the review of such content in connection with requests for benefits is very much put back in the forefront of our immigration processes. More to come, I'm sure, but that's the snippet for today.
Thank you very much for updating all of us. We really appreciate it. And please come on back, Caroline, when there is more to share. In the meanwhile, it's been a very useful update you've provided. Thank you. Let me turn to our next speaker. And as I noted in my introduction, it is Kyle Ritchie, who is back with us. He's a senior counsel based in Overland Park. And he wants to share with all of us, and certainly I want to hear about the evolving landscape of college student athletic compensation. This is a constantly moving target. We've had Kyle on in the past to provide updates, and here we are with another interim opportunity to learn from Kyle. So Kyle, thank you for taking the time. The floor is yours.
Thanks, Gabe. I appreciate it. Just as way of background, I did recently have an article that was published in the New York Bar Association, I believe, newsletter. So if you want to dig into any more detail or look at some of the case specific filings and stuff that I'm going to talk about, I would encourage you to either find that or contact us, and we can get you in contact with the document. But there's obviously, as Gabe had said, and I think if you're paying attention in higher ed, just in general, obviously things are changing on a pretty rapid basis as it relates to student athletes and being able to compensate student athletes. There's been significant movement, obviously, over the last 4 years, starting with name, image, and likeness, every state coming up with their own laws for the most part, conflicts with the NCAA, and then ultimately, we've had a lot of litigation surrounding various pieces of the NCAA's operations, how college athletics as we know it have known it in the past, and how that's moving in a different way. I'll talk about 2 cases in particular, and these are the couple that I address in the article, but these are probably the biggest cases that are out there right now. The more timely case is the House versus NCAA case. This is based on, it's a case based upon name, image, and likeness payments, back payments that should have been made to student athletes for the 4-year period before the case was filed, which is a $2.8 billion settlement amount that's been considered as part of the settlement negotiations. But that case also in the settlement agreement establishes basically a 10-year look forward period where institutions are allowed to directly compensate student athletes for name, image, likeness, to an amount up to a certain capped amount. This is obviously something that has never been really considered. Student athletes have been provided financial assistance or athletically related financial aid before, but obviously never direct payments over and above the cost of attendance for a student athlete. This is where we're at in this process. The settlement agreement, it was preliminarily approved back in, I believe it was October, was filed in late September, approved in early October of 2024, which set in motion the timeline for eventually for approval, or for at least moving down the road. April 7th was the final approval hearing that was held. There were 15 objectors that were invited to participate in the final approval hearing. The Judge Wilkin, had issue with only a couple of things as part of her review of the settlement agreement that's out there. So basically what's happening is we've got the settlement agreement that sets forth an annual amount of money based upon financially reported averages of the Power Four conference schools. And that number is around $20.5 million annually that an institution can share or pay for NIL related services to its student athletes. This is at the Division I level. An institution's not required to opt in. They're not required to make payments over and above, what they've already been doing in the past. But if they choose to, there are certain rules that will govern their activities. One of the biggest issues is a thing called roster limits. Roster limits, basically, in the past, you could have as many players on your team as you wanted, but you only had, say, 10 scholarships to divide up amongst those student athletes. So you could have 30 kids on a team, 10 scholarships. So you've got partial scholarships and kids that can walk on that don't need a scholarship. That idea of a scholarship limit is disappearing. We're going to have a roster limit, which means, for example, in football has 85 scholarships. They typically have 130 kids on the team. Now they have a roster limit of 105 student athletes, and that's all that can be on the team. They can all be on scholarship if you want them to be, but that's the limit as far as the student athletes that can be on there. There are a number of sports that the number of scholarships and the roster limits have gone up, and so they're providing more opportunity to student athletes. However, again, in sports like I said, like football, you're going to go from 130 kids to 105 kids, and kind of across the board, that's a significant decline in student athlete opportunities. So that's a piece that's been it's been hotly contested. There certainly are stories out there, and we're part of the objectors that, really tried to set the stage. I think the judge was sympathetic to that, and I think the judge wishes they would grandfather in a rule like this rather than moving to just immediately doing this upon approval of the settlement agreement. There was a filing yesterday. That was, essentially, if they were going to modify any of the settlement agreement. They did modify one little piece on a release of claims, but they did not address the roster limits. So it's been put forth for approval as is. So that'll be something to watch kind of as we go forward. I think the important thing with House is understanding that Title IX is not considered in the settlement agreement. It's not part of the settlement agreement. And Judge Wilkin had said, if you've got if there's a Title IX claim or something to come from this, that's outside of the settlement agreement. That's not anything related to this. So it's silent on purpose. The settlement agreement is silent on international student athletes related to immigration status and getting paid name, image, and likeness while on an F1 visa. That continues to be an issue of significant planning and significant concern, obviously, with student athletes across the board. And the last piece that it doesn't address, it has nothing to do with whether a student athlete is deemed an employee under the Fair Labor Standards Act or any other applicable law. And that leaves that to another case, which is the next one I'll jump into real quick. And this is just one to be aware of. This case is something we're still in the early stages, so it'll be something to watch because I think it's every bit as impactful, if not more so, than the House case. And it's Johnson v. the NCAA. It's based out of the Eastern District of Pennsylvania. And the claim is that employees of an institution are considered employees under the Fair Labor Standards Act. And so that was sort of the first question that's been out there. It's been in the interim. This case has been going on for a little over a year now, closer to 2. But there were some initial questions as far as just from a matter of law, is it possible that a student athlete could be an employee? And that case was actually appealed to the Third Circuit, early on in this case, to see, one, if that's possible, and then, 2, if it applies. And obviously Third Circuit punted on whether it applies, but they did determine that, it is possible that, that these standards could be applied. So, it's been kicked back to the district court. The motions to dismiss have just been filed by the defense. So we kind of, we're getting going, and that obviously discovery will be interesting as it goes forward, assuming those motions are denied. Just one other thing of note, and I'll finish out, is the Third Circuit, when it remanded the case back to the district court, tried to establish a new test for determining, an employee versus an independent contractor, as it applies more to college athletics and not the more nationwide standards that we've seen. And one of the big things that they tried to determine are, sports that are commercial in nature, talking about institutions making profit on sports, versus other sports that, are obviously in the alternative, not commercial in nature, or more of that typical college athletics as we've understood it over the past 50 or 60 years. And I think that really bears itself out when you look at the number of schools and the number of teams that are actually financially profitable versus those that are either closer to break even, or in fact, they do lose money for the institution. But, understanding that within the changing landscape of college athletics, we've got, if they're deemed employees, we've got a potential issue with a bunch of additional costs that would go with that determination. So a lot of things to keep in mind, a lot of questions that are out there, but that's the update for now.
Thank you. You're absolutely right. There is so much in play right now, and we appreciate you taking the time, Kyle, to update us. Please come on back when there's more to share. It's always fascinating, and we look forward to learning more. Now, for our last speaker of the day, we'll turn to Katie Stifler. And Katie, as I mentioned, is with us from our Rochester office. I enjoyed working with Katie and getting to know Katie's work. It's really terrific. And she brings a passion for school law, and in specific is here today to talk about the free appropriate public education plan and changes within that paradigm. Katie, the floor is yours. Kindly, there you go. Turn on your camera. We can see you. Wonderful. And please take it away.
All right. Good afternoon, everybody. Excited to round out today's program with you. So like Gabe said, today I'm going to be covering the topic of New York Public Schools' obligations to provide what we call a free appropriate public education. Next slide, please, Kathy. So in special ed law, we love acronyms. So we refer to this free appropriate public education as a FAPE. And I'm going to give us a little bit of background here before we dive into the recent development. So there's a few key laws at play. The first is a federal law. This is the Individuals with Disabilities Education Act, or the IDEA. It provides a lot of things, but for today's purposes, the most important takeaway is that the IDEA says that generally states have to make a free appropriate public education available to children with disabilities who are between the ages of 3 and 21, inclusive. And you'll see in a bit why inclusive is italicized and really important for our discussion today. We also have some New York State law. The first is a commissioner's regulation that tells us that the definition of a student with a disability is a student with a disability who has not yet turned 21 before September 1st. We have another New York State level law that addresses who is eligible for a FAPE. And this law tells us that a student or a child with a disability who turns 21 during the school year, which in New York State runs July 1st through June 30th, is entitled to finish out that school year. The last takeaway from this slide is that a New York public school district's obligation to provide this FAPE ends either when a student with a disability turns 21 or when they've earned a high school diploma, whichever of those occurs first. Next slide, please. So in 2021, we get this really important decision out of the Second Circuit, which is a federal court of appeals, and decisions from this court are binding on district courts in New York, which is why it is germane for our purposes. So in this case, the Second Circuit is looking at a situation where Connecticut was providing general education services to students, not students with disabilities, specifically access to GED programs until these students were 22. So the question before this court was it a violation of the IDEA to provide these general education services until students were 22, while not providing a free, appropriate public education to students with disabilities until they were 22? Now, as a reminder, in New York, the obligation to provide FAPE is until the student receives a diploma or the end of the school year in which they turn 21. The law is pretty clear on that. But this court says, we are interpreting the phrase from the IDEA that says that students with disabilities are entitled to a FAPE from 3 through 21 inclusive to mean every day up and until a student's 22nd birthday. And the court really hammers this home, and they say, in case this is not clear, what we mean is up until a student is 21 years old and 364 days. So at this point, we have the Second Circuit decision, which seems to come out of the different outcome than what New York state law tells us. So this led to a big question of what does this mean for New York public school districts' obligation to provide FAPE to students with disabilities? Next slide, please. So we fast forward a couple of years later, and the New York Education Department, or NYSED, says, okay, we get it. Folks are confused. We're getting a lot of questions from school districts about what does this mean? In this formal opinion from SED, they say, we fully embrace the Second Circuit decision in AR versus Board of Connecticut that says that school districts are obligated to provide a FAPE until a student turns 22. And the formal opinion goes on to say that the New York law is, quote unquote, materially indistinguishable from Connecticut law. And then SED goes so far as to say that they're interpreting the Second Circuit decision to actually require New York public schools to provide a FAPE to resident students with disabilities at least until their 22nd birthday. And then SED adds in that while the Second Circuit decision didn't address this, they're recommending that school districts provide a FAPE through the end of the school year in which the student turns 22, or when that student receives a high school diploma, whichever occurs first. So not only interpreting the decision to mean that school districts have to provide FAPE until a student turns 22, but also adding that they're recommending, while it's not legally required, their recommendation is that school districts provide a FAPE and related services for the duration of the school year in which that student turns 22. Next slide, please. Okay, so the story continues. In March of last year, we get this ruling from the Albany County Supreme Court. This is Katona-Lewisboro Union Free School District. And in this case, the Albany Supreme Court says it's very clear that the Second Circuit decision is contrary to New York law. They affirm what New York law currently says, which is that students with disabilities are entitled to a FAPE until the end of the school year when they turn 21, as opposed to until they turn 22. Now, New York State Ed has appealed this decision, and that appeal is currently pending. So we're not quite sure how this is going to play out. But in response to this court decision, SED chimes in again, and they release a memoranda confirming their position that students with disabilities in New York are entitled to FAPE until their 22nd birthday. And they confirm again that they are in agreement with that Second Circuit decision, despite this ruling from the Albany County Supreme Court. Next slide, please. Okay, but wait, there's more, because just last month, we get yet another decision from the same court, Albany County Supreme Court. This case involves Mahopac Central School District. And in this case, like in the one from March of last year, SED relies on the Second Circuit decision and says, look, the Second Circuit ruled on this. The obligation is for public school districts in New York to provide a FAPE until a student turns 22. But the Albany County Supreme Court goes a little bit further with this ruling, and they say, look, the bottom line is that New York law says that students are entitled to a FAPE until they've reached 21 or until they receive a high school diploma. They point out this is how the law defines it, and they're not sold by this argument that the Second Circuit decision should be binding. But then the court addresses a more global question, which is, what does it mean that we have a federal circuit court decision, and now we have a New York State Albany County decision that have reached different outcomes? And the court says this is really not in our wheelhouse to address. They say specifically it's beyond the scope of the Albany County Supreme Court's role to look at whether this 4-year-old Second Circuit decision means that the New York law, the way that it's currently written, is deficient under federal law. They say that that is not the precise question that was before them, and so they don't address that. So where this leaves New York public schools is that they're really going to have to determine how to manage this and how to move forward, because at this point we don't have additional guidance from SED, which makes sense because this most recent ruling was from about a month ago. But we have this situation where we have the Second Circuit decision and we have New York SED saying that they're in agreement with that. But now we have these two Albany County Supreme Court decisions that have reached the exact opposite outcome. So we may get some more analysis from the appellate division when they make a decision in that March 2024 decision that was appealed. But until then, school districts are going to have to make some decisions about how to manage this moving forward.
Well, thank you so much. That is really interesting, Katie. And I'm confident that you'll come on back if there are updates to share. In particular, you mentioned the appellate division is going to chime in. So I know that, those interested in school law and just understanding, those topical areas in law generally will be looking forward to what comes next. In the meanwhile, we've reached the end of today's program. And so if you'd like to be in touch with any of the speakers, their contact information is on the slide that Kathy's just put in front of you. And I just want to note that on a programming note, I will be back with you on April 29th. Carrie will be your host in a week's time. And in the meanwhile, we're wishing all of you a terrific afternoon and a good week ahead. For those of you celebrating holidays, we're wishing them to be full and peaceful. And we will be back with you soon. Thank you for your loyalty to the program. Have a great day.